Hello YouTube, and welcome back to my channel. On today's episode of Know Your Rights we are covering the Second Amendment. If this sounds interesting to you, please take a moment and subscribe to our channel. Now let's take a deep dive on the Second Amendment to the United States Constitution. The Second Amendment of the United States Constitution reads, "A well-regulated militia, being necessary to the security of a free state, the right of the people to keep and bear arms, shall not be infringed." Such language has created considerable debate regarding the amendment's intended scope. On the one hand, some believe that the amendment's phrase, "the right of the people to keep and bear arms," creates an individual constitutional right to possess firearms. Under this individual right theory, the United States Constitution restricts legislative bodies from prohibiting firearm possession. Or at the very least, the amendment renders prohibitory and restrictive regulation presumptively unconstitutional. On the other hand, some scholars point to the prefatory language, "a well-regulated militia," to argue that the framers intended only to restrict Congress from legislating away a state's right to self-defense. Scholars call this theory the collective rights theory. A collective rights theory of the Second Amendment asserts that citizens do not have an individual right to possess guns and that local, state, and federal legislative bodies therefore possess the authority to regulate firearms without implicating a constitutional right. In 1939, the U.S. Supreme Court considered the matter in United States v. Miller, 307 U.S. 174. There, the court adopted a collective rights approach, determining that Congress could regulate a sawed-off shotgun which moved in interstate commerce under the National Firearms Act of 1934. Because the evidence did not suggest that the shotgun has some reasonable relationship to the preservation or efficiency of a well-regulated militia. The court then explained that the framers included the Second Amendment to ensure the effectiveness of the military. This precedent stood for nearly 70 years until 2008, when the U.S. Supreme Court revisited the issue in the case of District of Columbia v. Heller, 478 F3D 370. The plaintiff in Heller challenged the constitutionality of a Washington, D.C. law which prohibited the possession of handguns. In a 5-4 decision, the court struck down the D.C. handgun ban as violative of that right. The court meticulously detailed the history and tradition of the Second Amendment at the time of the Constitutional Convention and proclaimed that the Second Amendment established an individual right for U.S. citizens to possess firearms. The court carved out Miller as an exception to the general rule that Americans may possess firearms, claiming that law-abiding citizens cannot use sawed-off shotguns for any law-abiding purpose. Similarly, the court in dicta stated that firearm regulations would not implicate the Second Amendment if that weaponry cannot be used for law-abiding purposes. Further, the court suggested that the United States Constitution would not disallow regulations prohibiting criminals and the mentally ill from firearm possession. In 2010, the court further strengthened Second Amendment protections in McDonald v. City of Chicago, 567 F3D 856. The plaintiff in McDonald challenged the constitutionality of the Chicago handgun ban, which prohibited handgun possession by almost all private citizens. In a 5-4 decision, the court, citing the intentions of the framers and ratifiers of the 14th Amendment, held that the Second Amendment applies to the states through the incorporation doctrine. The court lacked a majority on which specific clause of the 14th Amendment incorporates the fundamental right to keep and bear arms for the purpose of self-defense. While Justice Alito and his supporters looked to the Due Process Clause, Justice Thomas in his concurrence stated that the Privileges and Immunities Clause should justify incorporation. Several questions still remain unanswered, however, such as whether regulations less stringent than the D.C. statute implicate the Second Amendment, whether lower courts will apply their dicta regarding permissible restrictions, and what level of scrutiny the courts should apply when analyzing a statute that infringes on the Second Amendment. Generally, in constitutional law, courts subject statutes and ordinances to 3 levels of scrutiny, depending on the issue at hand. 1. Strict scrutiny. 2. Intermediate scrutiny. And 3. Rational basis. Circuit Court opinions following Heller suggests that courts are willing to uphold the following. Regulations prohibiting weapons on government property. U.S. v. Doroson, 350 Fed App 874, 5th CIR 2009, upholding defendant's conviction for bringing a handgun onto post office property. Regulations prohibiting possession of a handgun as a juvenile delinquent. U.S. v. Renee E. 583 F3D8, 1st CIR 2009, holding that the Juvenile Delinquency Act ban of juvenile possession of handguns did not violate the Second Amendment. Regulations requiring a permit to carry concealed weapon. Kochalski v. County of Westchester, 701 F3D81, 2nd CIR 2012, holding that a New York law preventing individuals from obtaining a license to possess a concealed firearm in public for general purposes unless the individual showed proper cause did not violate the Second Amendment. More recently, the U.S. Supreme Court reinforced its Heller ruling in Caetano v. Massachusetts, 136 SCT 1027, 2016. The court struck down a Massachusetts statute which prohibited the possession or use of stun guns, by finding that stun guns are protected under the Second Amendment. While ruling largely on the reasoning of Heller, the opinion was per curiam and therefore did not significantly add to Second Amendment jurisprudence. In 2020, the Second Circuit in New York State Rifle and Pistol Association v. Beach upheld a New York law which requires handgun applicants to show a proper cause for the issuance of the handgun license. In New York State Rifle and Pistol Association v. Brune, the U.S. Supreme Court granted certiorari in April 2021 to consider the Second Circuit's ruling and heard the parties' oral arguments on November 3, 2021. Some commentators believe that the court will strengthen the Second Amendment and limit states' ability to regulate firearms. Well, YouTube, I hope you liked this video. Please take a moment and subscribe to our channel. Until the next episode of Know Your Rights, stay safe out there.